Okay. Oh, good morning, everybody. Good morning. Can you hear me? Good morning, everyone. Let's get started. Can you hear me very well? This doesn't seem like it's... No? Oh, yeah, there we are. It is working. Right. Okay, we are going to crack on with defective buildings. We may even, this lecture may finish early. We'll see what we're going to cover. So remember yesterday we started and we talked about what the UK position is with defective buildings. And essentially they have said, unsurprisingly, given the UK position generally, that so it's recognised, firstly, as a pure economic loss. Sometimes it can be slightly difficult to get your head around. But I think that analogy with Donoghue and Stevenson is quite helpful, that it's similar to a claim by the purchaser of the ginger beer, not for the injury caused, but for the money wasted in buying it. Okay, so that's what a defective building claim is for. Someone has overpaid for what they've got. They've bought a dud. It's defective. It needs to be fixed, or it's worth less than what they have paid for it. So in the UK, they have said no liability unless you can show an assumption of responsibility. Now that's obviously extremely difficult for purchasers further down the line than the original kind of builder, of the original owner of the home who constructed it. But now we're going to look at the New Zealand approach, which is quite different. So in New Zealand, the case that so we're going to go through 5 cases. Bowen and Paramount Builders, Steeler and Porirua City Council, Hamlin and Invercargill City Council, Sunset Terraces, and Spencer on Byron. Now, as we're going through these, you might think, well, this all makes sense, this seems fair, this seems just, but then you might think, well, hold on, is it still, have we gone too far? Where should the line have been drawn? They're interesting questions. This is an interesting problem that the courts were confronted with. And perhaps when they were first confronted with the problem, they didn't realise how huge it would become, particularly in Auckland with the leaky buildings. So, first case, Bowen and Paramount Builders. This is from 1977. Now, and it's kind of really where you start with leaky buildings in New Zealand. So a builder put up a house on inadequate foundations for a Mr. Mackay. Now, before moving in, I think Mr. Mackay was a bit dubious about the house and he sold it on to the Bowens. Within a year, the centre of the house had dropped by 7 inches, which is quite significant. It's about, 7 inches is quite a decent amount. So doors were jamming. The line of the roof was no longer horizontal. Walls had cracked. Now, at the time, this claim was perceived not as being a claim for economic loss. Okay, the perception of this claim was that it was physical damage. So essentially a positive act of construction by way of defective foundations caused physical damage to the rest of the structure of the house. So this is the original way these claims were perceived, and then the perception has changed over time. But at this time, they thought this is physical damage. So the question was, is the builder liable for damage caused to the building itself by the defects he has created in it? And it was held, yes, he is. So that builder did owe a duty of care to the subsequent purchaser of the house for property damage to the house caused by the defects in its structure. Okay, now, like I say, this at the time, the way the courts perceived of this was as property damage, but that has changed to understanding it correctly as economic loss over time. But at this time, it was understood to be simply property damage. Now, the next case is Steeler and Porirua City Council. So this was a claim... so just to go back, just to provide, because it kind of makes sense when let's just jump back here. Back to Bowen. So they said in Bowen that actually a builder is liable for the negligent creation of a hidden defect which is a source of danger to persons whom he ought reasonably foresee as likely to suffer damage, either in the form of personal injury or injury to property. Okay, so it caused damage to the house and was a source of danger because of the defective foundations, things could fall down, etc. Now, this next case, there was no question of it being a source of danger. So this was brought by the owner of a defective building against the council who inspected the building and gave it a code of compliance. Now, this building was defective because the weatherboards were not of the standard required by the building bylaws. And because they weren't of the required standard, they were warping and they were twisting. Now, there's no question that just, warping, twisting weatherboards, this was not causing a danger to anyone inside the house. It was just inadequate in terms of the building itself. So the owner claimed against the council in their regulatory inspection role. And the court here recognised, unlike in Bowen, they recognised this is not a claim for physical damage. This is a claim for the purchase of a substandard residence. Okay, this is a claim for economic loss. And it went to the Court of Appeal. Now here, the Court of Appeal looked at the regulations that put the obligations onto the council when they were inspecting the buildings. And they said, look, these regulations are not confined to defects that affect the health and safety of persons, and they are not confined to defects that damage or threaten to damage other parts of the property. These regulations are wide enough to cover the safeguarding of persons who may occupy houses against the risk of acquiring a substandard residence. So it wasn't limited to this danger to the personal property, it was also the risk of acquiring a substandard residence. And this idea of substandard, well, that's there's room for interpretation that substandard might include paying too much for something that's not worth it. So because the construction of houses with good materials and in a workmanlike manner was within the council's control, the council owed a duty of care to persons against the risk that they would acquire a substandard residence. And this meant the claim for the economic loss suffered by having a house built with substandard weatherboards was successful. Now, this wasn't a claim for property damage, okay? So unlike Bowen, they now understand we're dealing with economic loss here. But the duty was still based on that broad ANZ inquiry, and the idea that there was a sufficient relationship between the council and the stealers, such as in reasonable contemplation of the council when they were carrying out their inspection process. Carelessness on its part might be likely to cause damage to the stealers in the form of this economic loss by acquiring a substandard residence. And there were no policy reasons that went against it. Note that there's no acknowledgement, once again, that actually because this is economic loss, maybe we need to kind of be a bit more nuanced in the approach. So there were a few cases that came on by, and then Murphy, before Hamlin, Murphy has been decided in the UK. Okay, so Murphy and Brentwood, big decision, no liability on the part of councils, unless you can show an assumption of responsibility. So the question that arose in New Zealand and Hamlin is, what is New Zealand going to do here? Are we going to follow Murphy, or are we going to do something different? So in 1972, the plaintiff, Mr. Hamlin, contracted with a builder for the construction of a house in Invercargill and applied to Invercargill City Council for a building permit. Now, the foundations of this house were inspected and they were approved by the building inspector from the council. Within 2 years, the first signs of something amiss began to appear, and during the next 15 years, continual cracks appeared. Doors were sticking. Now, Mr. Hamlin thought, well, maybe this is just normal. Maybe this is just the normal settling in of a new building. Maybe this is due to weather. He kept kind of explaining it away. It seems a little bit surprising, but sure, maybe this is... But by 1989, he said, actually, this is getting ridiculous. So he called in a builder to come and have a look at his property filled with cracked walls and stuck doors. And the builder said, I think we need to get an engineer in here to have a look. So the engineer came in and he looked at the foundations and he said, look, these are completely faulty and all these foundations need to be replaced. So at this point, Mr. Hamlin issued proceedings against the original builder who built the home with the faulty foundations and the council who inspected those foundations and gave them the tick of approval. Now, the builder had gone out of business, so he wasn't worth suing. So the focus of the case was on the liability of the council through the actions of the building inspector, who had approved foundations that were clearly faulty. So the question here was, well, did that council owe Mr. Hamlin a duty of care for the economic loss he had suffered because his home had been built on defective foundations? Now, the court distinguished Murphy, okay, and they distinguished it and they said, look, whatever happened in the UK, New Zealand homeowners traditionally rely on local authorities to exercise reasonable care not to allow unstable houses to be built in breach of the building bylaws. And this reliance that New Zealand homeowners have meant that the relationship between homeowners and the council incorporated a duty of care. I just want to point to these specific policy factors that were cited in detail in support of this. Okay, so the first is that New Zealand has a high proportion, this is in 1983, New Zealand has a high proportion of owner-occupied housing. Now the picture has probably changed since this time, but back in, when did I say it? So by the time this claim was heard, 1994, it was actually, New Zealand did have a really high proportion of owner-occupied housing relative to other jurisdictions. In New Zealand, a huge amount of the housing, particularly back at this time, was undertaken by small-scale building firms for individual purposes, okay, what they kind of call cottage building industry. So this was Mr. Hamlin building his home, getting a local builder, he built the house, this isn't some kind of broad, massive development type situation. The third point, they said, look, there is and has been considerable government support for private housing in New Zealand. So there was state-financed low-cost housing, low-interest loans were made available to facilitate home ownership. The fourth point was that there was a housing boom in New Zealand in the 1950s and 60s. I'm not sure about the relevance of that. I don't see how that makes any difference. Anyway. The fifth point, the others do, the others seem quite, robust policy reasons. I think the fifth point is that the wider central and local government support for private house building, there is this government support and they stipulate planning and they control the building process. And amongst this whole context, the sixth point, it's never been common practice for new house buyers in New Zealand to commission their own architectural or engineering surveys, particularly in that field of low-cost housing. There was this general reliance that the council's inspection process was robust. So it was the spirit of the times that the local authorities would provide a degree of expert oversight over the building of homes rather than expecting every single person building a house to take full responsibility and engage an expert advisor. And this is particularly so in this kind of realm of low-cost housing, where there isn't the funding to go and get your own experts when you can assume that the council are doing their job. So because of these factors, the court said that the question of whether or not it was just and equitable for the local authority to be under a duty of care to the owner and successors in title when inspecting houses, it needed to be considered against this background. Okay, this background where there is this huge amount of reliance on councils, people don't tend to get their own experts involved, the whole system of building is kind of stipulated through regulations, etc. And they found that the local authority did owe a duty of care to Mr. Hamlin for the pure economic loss he suffered when the council inspected the foundations and gave them a tick of approval when they were clearly faulty. So note that the test here, as always, is it fair, just and reasonable for there to be a duty of care on the part of the council to Mr. Hamlin? They didn't go down this route. Is there an assumption of responsibility? Okay, they just looked at the level of reliance of local authorities meant there was proximity enough to find a duty here. And when then it was appealed, Invercargill City Council then appealed it to the Privy Council, and the Privy Council did not overturn it. They recognised that in New Zealand, the position could be different because of the different societal context. And that was really a reflection of these factors identified by Justice Richardson that were particular to New Zealand. You know, this wasn't the case for housing in the UK. These factors were all particular to New Zealand. So, what we can take out of Hamlin, this is kind of the leading, original decision in New Zealand. They say, look, in New Zealand, the local authority owes the owner of a building, whether they are the first owner, a residential building, whether they are the first or a successive owner, a duty to take reasonable care in carrying out building inspections. And that local authority will be liable for the economic loss that is suffered as a result of negligence in the building inspection if that building is defective and the purchaser buys it unaware of those defects. The same duty is owed by the builder themselves to take reasonable care. It's eminently foreseeable that carelessness on the builder's part could cause damage to whoever owns the building at a time. The reality is that builders have often disappeared, and so the liability sits on the council. And unlike the UK, there is no requirement here for an assumption of responsibility. So what is also interesting is that for defective homes, general reliance on the inspections carried out by the local authority is enough. The fact that people say, I know, there is this process that I know about. Local authorities have to inspect buildings. There's this whole thing about compliance certificates. The fact that that is known is enough. And it's quite different to what we looked at when we were looking at the assumption of responsibility for negligent misstatements causing economic loss. In that case, this idea of general reliance isn't enough. There needed to be this more actual reliance, that someone has invited the plaintiff to rely on them, that someone has given the plaintiff the right to rely on them. And, they look at, well, what exactly are they saying? What will they protect you from? Is there an alignment of what you have specifically relied on? There's no requirement here to show that a purchaser has gone to the council file, rifled through it all, found the certificate of compliance and relied on that before purchasing the home. Okay, just the fact that there is a system in place in New Zealand is enough for there to be a duty of care. And actually what's interesting is that we can also reflect that this is, what do people think about it at this stage? Do you think this seems fair? If you're thinking, who should this loss rest on? Should it be the hapless owner who has purchased the home? Or should it be the council who had the power to inspect it. Foundations are then covered up, right? It's part of the building process. It's quite hard to look at them yourself. Any views? Does it seem like maybe in terms of if the law is doing a good job here, stepping in? Seeing some nods? Yeah. You know, I mean, I think these reasons that the courts have given are quite compelling. And I think they are particularly compelling for owner-occupied housing. But we're going to see, so this is a situation where tort law has made a choice, where the courts have made a choice in negligence liability purely on the basis of policy. Okay, this is not a situation that can clearly fit within coherent legal principle. But they've looked at policy and they've said, look, actually, for these reasons, it is fair, just and reasonable for there to be a duty of care owed by the council to the owner of a house for any defects in it. Because the council, the emphasis at this stage was on the general reliance placed on councils by building owners. And, you know, I think we can just reflect quickly on how this is different from negligent misstatement cases. So if instead of investing in a house, someone decides to invest in the share market, the law isn't going to help them out in the same way. You can't rely on a general system of regulations in the Securities Act that, you know, there are audited reports made available in a company proposal and expect that those auditors will owe you a duty of care unless you can show you have specifically relied on them. Okay, the fact that it exists, that was that case Boyd, Knight and Purdue, where they never actually turned their mind to what those accounts said. They just said, oh, there's an auditor's report, fine, the whole system seems good. Not enough in a negligent misstatement case that involves investment into the share market, but in a defective property case, the fact that there exists a system of regulation is enough to put the council on the hook for any negligence in the inspection process. Can you see that distinction? Yeah, that kind of difference between general reliance being enough for buildings, but not enough for negligent misstatement, leading to economic loss. Right. Just brief point, which is just, here's some knowledge, sorry. Another, just so that you kind of know how this works in practice, should you ever end up working in this field. Another issue which came up was all about limitation. Okay, so when should the limitation period run from in a defective building case? Is it the date that the negligent inspection was carried out? Or is it from the time the defective foundations were reasonably discoverable? Okay, so this is a really key question when you've got this latent defect that you can't see. And they said, look, because this was a claim for pure economic loss, that is only discovered once the defect is reasonably discoverable. At the time that it's reasonably discoverable, the property is worth less than what you've paid for it. So the time ran from that date. Now, this whole limitation issue is now governed by the Building Act 2004 and the Limitation Act 2010. So the Building Act provides this long stop period of 10 years from the date of the negligent act or omission, regardless of reasonable discoverability. And the Limitation Act has a period of 6 years from the date of the negligent act or omission to bring a claim. Unless you can show, so essentially you've got 6 years from the date of the inspection to bring the claim. If you can show that it wasn't reasonably discoverable within that period of time, you get an additional 4 years. So essentially a maximum long stop period of 10 years from the date to bring a claim. There we go. Right, so we've got this. This seems pretty robust, right? Like there are these specific reasons around why it might be good policy at this point to recognise a duty of care as owed. Now we're moving on to a different kind of case. So this is North Shore City Council and Body Corporate. I mean, sometimes even the names of these cases are boring. Body Corporate 188529, Sunset Terraces. So We know from Hamlin that the New Zealand Local Authority owes a duty of care when inspecting premises designed to be used as homes to ensure that prospective owners of those homes don't suffer pure economic loss as a result of defects in those properties. In Sunset Terraces, the New Zealand Supreme Court had been established, and they were invited to reconsider Hamlin. Do we still like this? Is this the approach? And by this time, this is 2010, I mean, the leaky building saga is well and truly, this has just become a massive problem. Now, the facts of Sunset Terraces were a little different from Hamlin. So Hamlin was just Mr. Hamlin building a house with a local cottage builder for himself to live in. Sunset Terraces didn't involve Ma and Pa contracting with a local cottage builder, but instead a property developer was building a big development of 21 townhouses. The townhouses were leaky and they rotted. There was untreated timber framing. There was monolithic cladding, the whole gamut of problems. So the body corporate and the owners of the units sued the council, alleging negligence in its inspection of the buildings. Now, the council tried to argue that a different approach should be taken in this case compared to the approach that was taken in Hamlin. They said, look, since Hamlin, we've had the Building Act 1991 that was in place and that governed this particular property development. And that Building Act showed an intention to move away from reliance on council inspectors. And they said, look, Hamlin involved the owners of a modest residence who could not be inspected to retain experts. In contrast, Sunset Terraces was built by a sophisticated property developer, and they could be expected to retain experts to ensure that this property was built properly and they could protect themselves through contractual arrangements whereby they get warranties in the contracts for quality of services. So this goes to kind of one of those, we've talked about those policy reasons that make courts reluctant to find duties of care for pure economic loss. And one of them is when someone has reasonable alternative means of protection. So what the council are arguing here is they're saying, we get it that Mr. Hamlin didn't have reasonable alternative means of protection. The whole situation there was quite different to this. We now have a very sophisticated property developer building something. They have reasonable alternative means of protection. Hamlin involved an owner-occupier, someone who built a house for themselves to live in. Sunset Terraces involved investors who bought the townhouses and rented them out. Or else they might have bought shares in a company, and that company then bought the townhouses and rented out. So again, a lot more sophisticated. And if we go back to some of these policy reasons, high proportion of owner-occupied housing, well, that doesn't apply to people who are investing in property. Housing construction undertaken by small-scale building firms for individual purchases didn't apply here. It was done by, a property developer. Considerable government support for private housing. Well, maybe. Housing boom, not relevant in any case. Wider central and local government support, fine. Not common practice for new house buyers to commission their own engineering surveys. Okay, some of these apply, but some of them don't apply, right? Particularly for the people investing. And they said, subsequent purchases into major developments rely on the original owner and the experts, they tried to argue, rather than the council. So what do you think? What's your take on it? Someone who's buying property as an investor, do you think, as opposed to an owner-occupier, do you think the position should be different here? No? People are shaking their heads. Does anyone any reason anyone wants to talk about around why you think the position should be the same? Yes?
Even if it's owned by an investor, the tenants of a residential property still going to be impacted by defects.
Yeah.
Unless there's a duty to the investor who suffered the economic loss that can never remedy the defects or destroy the tenant.
Yeah. To live in a defective house, yeah. Yep. I mean, and I think that might be one. Yeah, that's a good reason. Yeah. Yes. Yep. Lachlan?
Essentially, like, this is essentially going to what should the council's role be when it comes to doing inspections. And whoever the builder is,
Mm-hmm.
the council still has obligations to do the code of
Mm-hmm.
compliance checks, make sure
Mm-hmm.
that the building's up to code.
Yep.
And so just because it's a different builder
Yep.
doesn't necessarily change anything from the council's
Mm-hmm.
perspective. They still need to do their job.
Yep.
And so why should there be a difference?
Why should there be a difference in? Yeah. Yep. Yep. That's a good point. And, and a devil's advocate would say to this is another side. They might say, well, look, the position in Hamlin is based very much on policy and this kind of idea of general reliance on the fact that that councils inspect buildings. That idea of general reliance isn't so strong when you've got a sophisticated party who might have actual contracts they can rely on. They can look after their own interests. And when the councils are on the hook for all of this, everyone's on the hook, okay? So what that means is that, if you're paying rates, then your rates go up. If you're renting, your rent takes into account how high the rates are. So suddenly, people have bought a bad investment and everyone's having to pay more because the council's on the hook because of it. So, it's an interesting picture. When you get policy reasons, how far do you push the policy, or at what point do you say, actually, we think we've gone far enough here? Anyway, all of these arguments, kind of in line with what your view is, that all these arguments were unsuccessful. Okay, the council was on the hook. Councils owed a duty of care in their inspection role to owners, original and subsequent, of premises designed to be used as homes. Okay, didn't need to be owner-occupied, provided they were designed to be used as homes. Didn't matter if the home was an investment, which was tenanted. The duty was still owed to the owner. And they said, and this goes to, I think what Sion was saying, that protection of a non-owner occupant, such as a tenant, can be achieved only through a duty owed to an owner. And it is only the owner whose pocket is damaged as a result of the negligence of the building inspector, and only the owner who can undertake the necessary remedial action. So the rationale for the duty, there is this idea of control which the councils had over building projects, and the general reliance which people acquiring premises to be used as homes place on councils to have exercised their independent powers of inspection and control with reasonable skill and care. And this is in particular of features that are covered up as the building progresses, foundations, the timber that's inside the cladding and all that kind of thing. Right. Now, Tipping J said, a question that's vexed some jurisdictions is that the difference between physical damage and economic loss. Our jurisprudence has never treated this distinction as critical in determining whether a duty of care is owed. I mean, actually, that has been the cause of quite a lot of confusion in our law, but, it doesn't need to be critical, but it should be relevant. Okay, it should be relevant. It should make courts pause and think, how are we going to go down this path so that the line is clearly defined? Anyway, so we've got Hamlin. Councils are liable to owner-occupiers of homes for negligent inspections causing pure economic loss. Then we get Sunset Terraces, and they say this applies provided the property is designed as a home. It's fine if it's an investment property. The only condition is that it's residential property. The next case is Spencer on Byron. What if it's commercial property? Is the council still liable? Okay, so let's just rip back up to these key 6 factors that supported our initial kind of fork in the road with the UK. How many of these apply to a commercial premise? Any? None? Which ones, if any? Hands up if you think none apply. Yep, I can see one hand is up. The rest of you, tell me which ones you think apply. or tell me if you think none apply. Yes, Sion?
There might still be some, maybe not considerable, but there's still governmental support for commercial property.
Yep. On the whole, is your take that this seems to be more directed to residential homes than commercial? Oh, yeah, Lachlan?
Yeah, on the face of it, all of these are very much focused on housing.
Yeah.
But sometimes the distinction between commercial and residential is a little bit arbitrary.
Yeah.
A lot of people do their work, do fund businesses at home, business places, residences that were originally designed for commercial use might eventually become housing in the future.
Okay, yep, so it's not a clear-cut distinction. Yeah, and that's a valid point. Yeah. So, what we can say is this does, there is, yeah, okay. So, where are we? Spencer on Byron. This was a 23-storey development in Takapuna. Just actually like you mentioned, sometimes the picture is not entirely clear, okay? So, it had both residential and commercial uses. And they both sued the council for negligent inspection. Now, the High Court struck out the claims by the owners of the property being used for commercial purposes. They said, look, the commercial use, you're out. Residential, you're in. Okay, so they drew a line between the two. The Court of Appeal said, it's all or nothing. We can't draw random arbitrary lines in the same building. The essential character of this building is commercial. Everyone's out. No duty of care to anyone. Supreme Court said, no, actually, there's a duty of care to everyone. So the councils owed a duty of care in their inspection role to both original and subsequent owners of premises, regardless of whether they were residential or commercial. And the Supreme Court found that there was proximity between them to ground that duty of care. Proximity was centred now, so historically proximity in these cases has been centred on this idea of general reliance. But here they were like, yeah, we do kind of accept that sophisticated developers of commercial premises don't actually have that kind of reliance on the council. So we're just going to shift the dial away from general reliance and we're going to put it into control. We're going to centre proximity on the basis of control. The council controls the building process to ensure it conforms with the building code. It's eminently foreseeable that carelessness on the part of the council may cause loss to present and future owners. And they said, look, so they've shifted the dial away from reliance to control because reliance, they couldn't keep relying on reliance because reliance didn't really work in a commercial kind of context. But they could put emphasis on control, and the control that councils have applies both to residential and commercial properties, okay? Councils have this control over the building processes when they inspect them, when they give them the big tick to say, this is code compliant. Now, this is very much, and they say the duty of care was to protect the habitation interest of those who used buildings as well as the economic interest of the owners. There were no policy reasons that made it fair, just and reasonable to restrict the duty of care to residential properties. The Supreme Court then said the underpinning rationale of the duty of care is the need to provide encouragement to those responsible for the construction of buildings to use reasonable care in their respective tasks within that overall undertaking. It makes more sense economically for liability to fall on those responsible for negligent construction, including, where appropriate, the inspecting authority which saw the building under construction and was therefore in a position to prevent defective construction occurring. So, I just want to go through some of the things said by the majority. You know, one of the issues you get with a case like this, when you have a duty of care based entirely on policy, and then you just keep pushing it and kind of saying, oh, we'll use this policy now and this policy here, they kind of got so far down the hill and they just kept going. Other countries, which we'll talk about, have taken different approaches. If the courts had stepped back from this at the beginning and said, this is not appropriate for the common law to resolve this problem, this is for the legislature to get involved and stipulate who owes who a duty of care, what kind of property it must be, then you can draw these lines, these more arbitrary lines. But we get to this point where, you know, it's not principled law, it's policy-based law, but sometimes it's got to the point that maybe it's also bad policy. I don't know. These are things that you can think about. But in Spencer, they were directed to Attorney General in Carter. Now, remember that case we talked about the boat and about the regulations, all being about, is the boat seaworthy? And then someone relied on the fact the boat was seaworthy to work out how much they wanted to pay for the boat. And the statutory body who provided the seaworthy certificate wasn't liable for the economic loss. Okay, so they were directed to that. They said, look, you know, this is... And they were directed at it because the council said, like, you've got to look at what the statutory purpose of the certificate was, what the purpose of the statutory scheme was. And the Supreme Court said, well, we distinguish Carter because it involved different legislation. Fair enough. Of course, it involved different legislation. But surely the purpose of that legislation that gives the body its powers and duties is determinative in one kind of case, causing pure economic loss, then it should be also determinative in another. Why is it relevant in one case but not in another case? And like Carter, the legislation involved in the Building Act 1991, which was the relevant legislation that this building was built under, doesn't say anything about protecting economic interests. It's all about safety and sanitation of homes. Okay, so maybe right at the beginning there was something to do with risks of requiring substandard residences, but things have moved on by the Building Act 1991. It's all about safety and sanitation. So there seems to be a different approach, different emphasis placed on legislative schemes, which seems inconsistent. They then said in terms of reliance, that only has a very limited role to play in the tort of negligence as opposed to the tort of negligent misstatement. In contrast to the UK courts, and so the UK courts very much focus on what the loss is. Is it economic? Is it physical? In New Zealand, the focus is more on how is the loss caused. Is it caused by negligent misstatement, in which case we'll go down the assumption of responsibility approach, and is it actually caused by a negligent service, in which case we might revert back to ANZ. Okay, can you see that distinction? And they said, look, it was enough that for 2 decades, New Zealand society had got used to a legal regime under which local authorities could be liable for negligence if their building inspectors carried out their professional duties negligently. So this reliance that they did put emphasis on was not reliance on the compliance certificate, it was reliance on the state of the law in New Zealand around who would be liable. It's quite a different emphasis. And, you know, maybe there's something in that for residential homes. I'm not sure there is for commercial properties, because that reliance didn't exist. The general vibe has been that it is thought that reasonable alternative means of protection are available for sophisticated owners of commercial properties to protect their own interests here through the contracts that they arrange with the parties who they do the construction services with. Okay, so that's the kind of reason why people think actually the law's gone too far here, and also putting the local authorities on the hook for commercial premises. The dissent of William Young was a pretty good dissent, I thought. It showed a more nuanced understanding of the principles. He says, look, Donoghue and Stevenson, this whole proximity approach, but this all makes perfect sense when the foreseeable loss is physical. It's not so easily applicable to economic loss. in terms of the control over the building process on which the duty of care was based, he said, his view was that actually that's just a facet of foreseeability. Unless someone's act or omission has the potential to adversely affect others, there can't be the possibility of foreseeable loss being caused. So to point to the control that the local authority has over under a building regime doesn't explain why the duty of care should be imposed. And I think this is really important. In terms of consistency with other parts of the law, he noted that similar duties are not imposed on other regulators within New Zealand, even when they are in a position of control of a regulatory scheme from which loss can flow. Okay, so there's this inconsistency that relates to buildings as compared to other ways that loss can flow. He then, sorry, I can see we're kind of running short of time. He looked at the purpose of the legislation under which this building was constructed, and he compared it to some of those other cases we've looked at, and he said, look, the legislation has changed. Sure, there was that whole substandard residence thing under Steeler. That's now out of the legislation by the time this was built. So, you know, the protection of economic interests was no longer a justification of building controls by the time this was built. The focus is all about health and safety. Anyway, we will leave Spencer and Byron there, and the final slide is let's just compare how New Zealand approaches these problems compared to other jurisdictions. So in New Zealand, duty is owed by builders and controlling local authorities to owners and subsequent purchasers, that should read, for all defects, doesn't matter if they're dangerous or not dangerous, and it applies to both residential and commercial buildings, to owner-occupied and investment. It applies to everything. Any building, duty's there, okay? UK, no duty anywhere unless it has caused physical damage. Now, someone came up yesterday and mentioned, like the difference between tyre. You know how there was all that comparison the UK do, where they go, what would happen if it was a tyre? What happens if it's a car, and we've got to apply the same approach to a house? Well, there's an idea that the UK approach is actually too harsh, because you can't just discard a house like you can a tyre. So maybe there is justification for a different approach for houses. What happens if you can't afford to fix the defect, and the defect ultimately results in physical injury or property damage? So the UK approach is not necessarily the right approach either. It's a difficult problem. In Canada, the duty is only in respect of dangerous defects, and this is justified on the basis that it protects the bodily integrity and property interest of the inhabitants of the building. Outside that, it's just economic loss. You can only recover that through assumption of responsibility. Defective quality is usually remedied through contract. Australia, duty is owed in respect of both dangerous and non-dangerous defects, but only for residential properties. Okay, so we've got some jurisdictions who've drawn the line between dangerous and non-dangerous. And we've got some jurisdictions who've drawn the line between residential and commercial. We've got some jurisdictions who've just said no recovery at all. That is the UK. And then we've got New Zealand that has just opened the doors to all of it. So there we have it. That is defective buildings for you. So Joe will be here for the next 2 weeks doing pure mental harm, and then I'll be back with other cases. Hi.
Sorry, I'm just wondering, because I work in the medical industry.
Yeah.
I was wondering, wasn't there like a legislation changes coming up to not let out claims to councils and stuff?
And new legislation change coming up. I'm not sure. Is there?
So I think there is one, but
Oh,
I'm not sure
interesting.
if there will be one like before the end of the exams.
Oh,
It was
don't worry.
talking
If
about-
I haven't taught you on it, don't expect. Yeah.
Because the last time the minister
Maybe you
was
should be
talking about...
examining me on that.
The last time the minister was talking about, because, it's like wasting the rates, because essentially the council gets their money from the rates.
I know.
Yeah,
We're all
so-
paying for
so-
owners of commercial buildings.
So that's basically
Yeah,
what's
exactly. They could protect themselves through proper, robust contracts, and see we're all paying for it, whether it's through rent or rates or
Yeah, I
whatever.
think the entire industry right now is like
Yeah.
looking to get that changed.
Yes,
So I think
interesting.
they're pushing very hard on
Yeah,
it. And
right.
I think Chris Payne, so the Minister for Housing,
Yeah.
he's thinking about doing a change.
Interesting.
Okay, so it's
Okay.
not that cool.
Yeah.
Yeah, I I think that makes more sense.
It does, yeah, absolutely. Hi.
So I just have two questions about
Yeah.
Number one, is it true that you're not allowed to use cases outside the critical price?
Yes, for remote, are you talking about?
Yes, and also
so there's the reading list, and then there are lecture slides, okay, and lectures. So if the case has been mentioned on lecture slides, but it's on the reading list, you should be able, rely on whatever's being taught to you. But we just don't want people to go off and kind of plug it into, it's an AI issue, really. That's the reason.
I mean, I was
No,
gonna
I'm
use
sure
that.
you will.
Maybe if I'm running out of time, which I kind of am because mine's on Wednesday morning next
Yeah.
week. So I might use summarize some facts, but I'm not gonna be like, what are the cases for this?
No, I mean, the general view is that we don't want you using AI. Yeah, so please don't. But I'll leave you to work out.
Okay.
Make sure you understand.
Second question. Only Joe's content is relevant to that, right?
To what?
To the moods right now. Because I'm arguing for Council C.
Oh yes, she did the CV. Yeah, I wrote the nuisance part of that. Yes, so it's just Joe's.
Okay, sweet. So it's just duty of care to breach of, is it breach of duty?
I don't know. You have to read it and work it out.
All of negligence, pretty much.
Yeah.
But not like.
Not my material. It's not pure economic loss. Yeah.
It's more like because it's not pure economic loss. The guy got his Rolls Royce wrecked, so it's different.
Yeah.
Right.
Physical damage sounds like. Yeah.
Yeah, it does.
Yeah.
Thanks.
Cool.